Making a will is crucial for ensuring your wishes are carried out after your passing, and in this video, we'll break down the legal requirements for making a will in the UK. Before we get started, make sure to like, subscribe, and leave a comment below. We'd love to hear your thoughts and questions. In this video, we'll cover everything you need to know about creating a valid will in the UK. From who can make a will to the specific elements that make it legally binding, we've got you covered. Whether you're planning to write your own will or get professional help, it's essential to understand the legal aspects. We'll also discuss the common mistakes people make when drafting their wills. Avoiding these pitfalls can save your loved ones from unnecessary stress and legal issues. So stay tuned for valuable insights that will help you create a will that stands up in court. Lastly, we'll touch on the importance of keeping your will up to date. Life changes, and so should your will. Knowing when and how to update your will ensures your wishes are always in line with your current situation. First and foremost, you need to be at least 18 years old to make a will in the UK. This is a strict legal requirement, with very few exceptions. In some rare cases, if you're in the armed forces, you might be able to make a will before turning 18. Next, you must have the mental capacity to make a will. This means you should understand the nature of the document you're creating, the extent of your property, and the potential claims against your estate. If there's any doubt about your mental capacity, it might be wise to get a medical opinion. Your will must be made voluntarily. This means you shouldn't be under any pressure or undue influence from others when making your will. If there's any suspicion that you were coerced, your will could be challenged in court. A will must be in writing to be valid. This can be handwritten or typed, but it needs to be a physical document. Verbal wills, also known as nuncupative wills, are not recognized in the UK. You must sign your will in the presence of 2 witnesses. These witnesses must also sign the will in your presence. It's essential that all parties are in the same room at the same time when signing. Your witnesses need to be over 18 and must not be beneficiaries of the will. If a witness stands to inherit from your will, their inheritance could be invalidated. It's best to choose witnesses who have no personal interest in your estate. Your signature must be at the end of the will. If you sign anywhere else, the will might not be valid. This might seem like a small detail, but it's crucial for the document's legality. It's a good idea to date your will when you sign it. This isn't a legal requirement, but it can help avoid confusion later on. If you make any changes to your will, dating those changes can show which version is the most recent. If you make changes to your will, you must follow the same formalities as when you first created it. You can either add a codicil or make an entirely new will. A codicil is an amendment to your original will and must be signed and witnessed in the same way. Destroying an old will is essential if you're making a new one. This ensures there's no confusion about which will is the valid one. You can tear, burn, or otherwise destroy the old document. Storing your will safely is crucial. You can keep it at home with your solicitor or use a will storage service. Just make sure your executors know where to find it. It's important to review your will regularly. Major life events like marriage, divorce, or the birth of a child can affect your will. Ensure it always reflects your current wishes. If you marry, your will is automatically revoked unless it was made in contemplation of marriage. This means you'll need to create a new will after tying the knot. Divorce doesn't automatically revoke a will, but it does affect any gifts to your ex-spouse. If you have any doubts about your will, it's best to seek legal advice. A solicitor can help ensure your will is valid and meets all legal requirements. This can give you peace of mind that your wishes will be respected. In the next part of this video, we'll delve deeper into specific scenarios and answer some common questions about making a will in the UK. Stay tuned for more. All right, let's talk about the steps to take when making a will in the UK. This will help ensure your will is legally sound and reflects your wishes. Step 1. Decide what you want to include in your will. Make a list of your assets, including property, savings, and personal belongings. Think about who you want to inherit these items. Step 2. Choose your executors. These are the people responsible for carrying out your will after you pass away. Make sure they are trustworthy and willing to take on this responsibility. Step 3. Consider guardians for any children under 18. This is crucial if you have young children, as it determines who will look after them. Discuss your choice with the person you want to appoint to ensure they are happy with it. Step 4. Write your will. You can do this yourself using a template or seek professional help from a solicitor. If your estate is complex, it might be wise to get legal advice to avoid any issues. Step 5. Sign your will in the presence of 2 witnesses. Remember, these witnesses must be over 18 and not beneficiaries of the will. They need to sign the will in your presence as well. Step 6. Store your will safely. Keep it in a secure place where your executors can easily find it. You might want to give a copy to your solicitor or use a will storage service. Step 7. Review and update your will regularly. Major life changes like marriage, divorce, or the birth of a child can affect your will. Make sure it always reflects your current wishes. Step 8. Inform your executors and loved ones about your will. They need to know where to find it and what your wishes are. This can help avoid any confusion or disputes after your passing. Before we move on to the rest of the video, if you are finding this helpful, please like, subscribe, and comment, as it really helps this video reach a wider audience. Here is an example of how the legal requirements for making a will in the UK can play out. Meet Sarah, a 45-year-old from Manchester who decided it was time to make a will. Sarah owned a house, had savings, and some valuable personal belongings. She wanted to ensure her 2 children and her favorite charity would benefit from her estate. Sarah followed all the legal steps to create her will. She listed her assets, chose her sister as her executor, and appointed her brother and a family friend as witnesses. After signing the will, she stored it safely with her solicitor and informed her family where to find it. Sarah regularly reviewed her will, especially after significant life events, to keep it up to date. Now, here are some actionable steps you can follow to make sure your will is legally sound. First, take the time to list all your assets and think carefully about who should inherit them. This initial planning can make writing your will much easier. Next, choose reliable executors who will carry out your wishes. Make sure they are aware of this responsibility and are willing to take it on. Don't forget to get your will signed and witnessed correctly. This step is crucial for its validity. Finally, store your will in a safe place and let your executors know where it is. Regularly review and update your will to reflect any major life changes. Doing this ensures your wishes are always current. If you found this video useful, please like and subscribe. It really helps us out, and we would greatly appreciate it